Labour Party or PDP. It is very important. Let me remind you again that not only Labour Party and PDP now sue APC and President Tinubu go court. There were 5 people, 2 don't withdraw. APM still there. So Labour Party, PDP and APM were the people who sued the APC and President Tinubu to court. So the first judgment was on the case of the APM. Now what is the case? The APM said, first and foremost, when Tinubu win presidential primary for APC, not be Shettima be vice presidential candidate running it. It was Ibrahim Masari that was initially the vice presidential candidate. But Masari wrote a letter to withdraw as the vice presidential candidate. He said not do again. He cited 1 or 2 reasons for his decision. Then Tinubu nominated Shettima. APM say before I say Masari don't withdraw, he said the ticket na joint ticket wey Tinubu and Masari get. Say so when Masari don't withdraw, that ticket is null and void. Say APC is supposed to conduct another presidential primary. So therefore, Tinubu is an invalidate candidate. Let me read you the judgment. The Presidential Election Petition Court, PEPC, sitting in Abuja, has dismissed as incompetent the case the Allied People Movement APM filed to nullify President Bola Tinubu's election. The court held that the issues APM raised in its petitions contain pre-election matters that could only be determined by the Federal High Court. Chairman of the panel, Justice Haruna Samani, who read the ruling, upheld preliminary objections that all the respondents raised to challenge the competence of the petition. Justice Haruna noted that since the petition centered on the qualification or otherwise of President Tinubu to contest the presidential election that held on February 25th, the APM ought to have gone to court within 14 days after Tinubu was nominated by the APC. He held that since the cause of the action bordered on a pre-election matter, the APM lacked the local standing to challenge Tinubu's nomination. More so, Justice Samani held that the Supreme Court had earlier decided that a political party does not have the right to challenge a nomination that was made by another political party. He held that Section 131 and 237 of the 1999 Constitution, as amended, made provisions for the qualification or disqualification of candidates in an election. The court noted that the main grounds of the APM was on the alleged invalid nomination of Tinubu's running mate, Shettima. It is clear that the claim of qualification, its non-qualification of the third respondent, that is Tinubu, centered on alleged invalid nomination of the fourth respondent, which is Shettima. It is a pre-election matter, Justice Samani held. He further held that Section 84, subsection 3 of the Electoral Act 2022 stipulated that political parties should not impose qualification criteria on a candidate except as provided for in the Constitution. According to the courts, Section 65, 66, 106, 107, 131, 137, 185, and 187 of the 99 Constitution, as amended, settle the issue of qualification and nomination of candidates for an election. It's held that where an election has already been conducted and result declared, the qualification of a candidate could no longer be challenged on the basis of Section 131 and 137 of the Constitution. The court held that since the APM failed to challenge President Tinubu's nomination within the constitutionally allowed period, its case therefore has become statute bound. It's held that where the Constitution has qualified a candidate for an election, no other law can disqualify such candidate except the Constitution itself. The court held that the issue of double nomination as canvassed by the APM was not a legally cognizable ground for disqualification. Besides, the court held that it found no reason why Ibrahim Masari was cited as the fifth respondent in the petition, since he would not in any way be affected by the outcome of the case. Consequently, he struck out his name from the petition. The APM and it had in its petition argued that the withdrawal of Mr. Masari, who was initially nominated as vice presidential candidate of the APC, invalidated Tinubu's candidacy in the view of Section 131C and 142 of the 1999 Constitution as amended. The party argued that there was a gap of about 3 weeks between the period that Masari, who was listed as the fifth respondent to the petition, expressed intention to withdraw. The actual withdrawal of his purported nomination and the time Tinubu purportedly replaced him with Senator Kashim Shettima. He further argued that Tinubu candidature had elapsed at the time he nominated Shettima as Masari's replacement. According to the petitioner, as at the time Tinubu announced Shettima as the vice presidential candidate, he was no longer in a position constitutionally to nominate a running mate, since he had ceased to be a presidential candidate of the second respondent, having regards to the provision of section 142 of the 1999 constitution. The APM contended that Masari's initial nomination activated his joint ticket, principle enshrined in the constitution, stressing that his subsequent withdrawal invalidated the said joint ticket. He therefore prayed the court to declare that Shettima was not qualified to contest as the vice presidential candidate of the APC as at February 25, when the election was conducted by INEC, having violated the provisions of the section 35 of the Electoral Act 2022. And order nullifying and voiding all the votes scored by Tinubu in the presidential election in view of his non-qualification as a result of as a candidate of the APC, as well as an order to set aside the certificate of return that was issued to the president by INEC, reliefs that were rejected by the court on Wednesday. Now, for Justice Samani to read this judgment took him almost 2 hours, but I'm going to explain it briefly. The court is saying that the issue of whether a candidate is qualified or not, now pre-election matter. That means you're supposed to take that case to court 14 days after the presidential primary. That's one. Secondly, you are not supposed to bring it to the election tribunal. You're supposed to take it to the federal high court. Thirdly, it is only somebody in the APC who ran for the presidential primary that can challenge that issue in court. Not be another party altogether. They say not concern APM. So APM cannot challenge the matter in court. And APM even list Masari as a field respondent. There's already concern Masari. Masari say no do again. Why you the charger to court say he no do again? So the court cancelled that case, declared that Shettima and Tinubu's ticket is valid and the fight of APM does not work. They should have taken that matter up before the election, and they are not even qualified to take the matter up. The thing not happen for their party. That is the first judgment. We are waiting for the rest judgment to come. As they come, I'm going to give you a gist. I get work.